Ladies and gents, welcome back. We're 2 years on, and we're still seeing in British Columbia and several other provinces where nurses and healthcare workers are not being hired back. In British Columbia, for example, they've actually even renewed their vaccine mandates recently. And well, there's a case actually going on. And to talk about this case, I brought on Eva Chipiuk to talk about, well, what happened 2 years ago and how we're finally getting our day in court. What's happening with this?
Well, you know what? It's a really interesting case, like you said, that has been going on for well over 2 years and kind of unnoticed. It's a class action lawsuit that was brought forward first by a resident of BC, and then he incorporated a not for profit organization specifically to bring this class action lawsuit. So, literally, at this point, one of the classes is everybody over the age of 18 that is a resident of BC that was affected by the emergency declaration. And what's really interesting about this case compared to every other COVID case that has been heard in court thus far is that this one isn't really arguing about COVID per se or vaccine mandates per se, but it's going straight to the emergency declaration that was made by the province and by Bonnie Henry.
Okay, so what is the criteria for declaring a state of emergency in law? I mean, I don't understand this. I know that they've been using these emergency powers ever since the pandemic, and this has just been an ongoing thing. Renew. As soon as it gets challenged, we saw on the federal level, they just pull it and then declare it moot. What are the chances of something like that happening in this case?
Well, that's a really interesting question. And somebody brought that up today in the gallery, not in court. And I have to say, if the government brings a mootness application after this, I can't see how the court is going to entertain that, because this has taken a lot of time and effort to bring this matter forward. And this is a certification. So we're going kind of through all these tests and hurdles, the plaintiffs are, to say that this class of people should be certified for this reason. If after that stage, the government comes to the court and says, all of this should be moot, I don't think it would be appropriate for them to do that. They would have, in my opinion, they would have had to do that in this hearing or before. What's different is in all the other cases, that step didn't take place. This is a very preliminary and very administrative part. Mootness is an administrative matter. It's not about actual evidence. It's about whether or not procedurally it makes sense for the court to hear it. So if we're spending the 2.5 years to get to this point about whether or not procedurally this should move forward, I would find it very, very difficult for the government to bring that argument later. But to be honest, the government has been bringing very strange applications, so I wouldn't hold it past them. I would hope that the court would not entertain it, though.
So, I mean, you're saying it would be inappropriate. We've seen a lot of inappropriate things from our government in the past 3 years. We'll just say that for sure. But where do we go from here? The government's been using emergency powers as just like a way of ruling the people. Why couldn't they do something where they actually enacted some sort of law? They've had 2 years to do this, and yet they still just keep using emergency powers. Is there a reason why they can't make new laws?
Very good question, Clyde. I don't have the answer for that. I think that would be more appropriate 3 years into this emergency. I think we have to start really looking at the definition of what an emergency is, because at this point, I think we're overusing and abusing the word if 3 years later we're talking about an emergency and relying on that to govern Canadians and BC residents in this case. So great question. I don't have the answer for you. Hopefully the government does.
Well, yeah, that would be great. And this is something they probably have to answer to in this hearing. So what are we looking forward to in the next week as this plays out? What's procedurally, and how do you think this is going to play out in a court case?
So all this week is, and it's a full week of a hearing, is basically most of the time is going to be taken by the government lawyers opposing certification of this class action. So earlier, I think it was in December, there was already basically a week of this where the plaintiffs were arguing why this should be certified. And now it's the government lawyers that are saying why it should not be certified. On the last day, the plaintiffs have an opportunity to respond to all of the arguments. And what you'll see probably at the end of the week, I anticipate is, and I'm not obviously the lawyer on the case, I'm just trying to educate and raise awareness about what's going on here with this case, is that my anticipation is that the plaintiff lawyer is going to bring forward very specific classes that the judge can go back with and say, okay, I'm going to go with class A or B or C. So it might not be that every single resident over the age of 18. It might be, for example, because they've made these arguments already, that anybody that had a vaccine and then wasn't able to get another one because of adverse impacts, those people should be classified because there was something preventing them to get that. There was no way that they could do anything. So they're going to try to provide a class that is going to be more reasonable for the court to comprehend it, because I do understand this. If it's classified as a class or certified as a class action for anybody over the age of 18, wow, is this going to be a big case to manage?
Yeah.
So I think what's going to happen is, I hope and I believe that it will be certified, but maybe for specific groups of identifiable BC residents.
Well, I know a lot of people who were coerced into it and ended up getting the medical procedure that was pushed onto them might want to raise their voice in this. Absolutely. Not just people who didn't actually get it or didn't get it for any good reason. Now, what if you end up in that? Because I'm a resident of British Columbia. I'm over 18 years old. What happens if I fall under that class? What happens if anyone who's out there in the audience falls into that class? Is there something that they should do? Is there something that they could do to get involved in this case?
So what's actually really interesting about the Class Proceeding Act in BC is that if you are part of that identified class, you're actually already in it. You don't have to opt in. You don't have to raise your hand. You don't have to fill out a form. You're automatically in that class proceeding. So I can see why the government is challenging this very hard, because that's how the law is drafted in BC. In other provinces, it's different, is you have to learn about it and then once it's certified, you have to basically raise your hand or fill out a form and say, I want to be part of that class. I identify and have reasons to be part of that class. In BC, you're already opted in. You're already part of it. So you don't actually have to do anything. All you have to do is keep an eye out on things.
Oh, cool. Okay, so that's good to know. Now, here's the big question. If they deny this in this hearing this week, they don't allow any classes. Is that a possibility?
Of course, yes.
And then what happens moving forward from there?
Well, I would anticipate that the plaintiffs would challenge that. They would appeal that in the BC Court of Appeal. So they would bring it to the higher level court and ask the higher level court to determine whether or not that is a correct ruling.
Okay, that makes sense. Now let's assume that a class is designated, maybe not the whole class, maybe it's more narrowly designated. What happens from there? What's the next procedure in this court case?
Well, then it gets to the real good stuff. Then the actual evidence comes in, because for 2.5 years, like I was saying, it's just administrative and procedural. So there's been one expert report that's been submitted as evidence, but it hasn't been relied upon too much, which I understand. But then the next part would be expert reports, cross-examinations of those experts, including the defendants themselves, which would be Bonnie Henry. So she would be subject to cross-examination. The lawyers cross-examining her would be asking for undertakings, which means that if she relies on something, you want to have evidence of that, documents of that. So this would be really getting to basically what she knew when and why she made the decisions that she made, and she would have to produce evidence to support all of that, and that would be super interesting to get to.
How much longer are we looking to this whole situation? Is this something that could happen overnight, or is this something that's going to get stretched on and we're just going to hear about it down the road another 2 years or something like that?
Well, no, I don't think so. I think once this bit is wrapped up at the end of this week, there's no more hearing time to argue the preliminary matter of certification. Then it's just up to the judge to make a decision, which, that one I can't tell when that's going to be, but I'd anticipate 1 to 3 months. That's generally, a good rule of thumb. And once that moves forward, that it should move forward pretty quickly. The other thing is, I do believe that some time has already been reserved to cross-examine Dr. Henry. So the parties are making steps in order to continue to move the case forward. So that is positive.
Oh, that's brilliant. So one last question. Will it be live streamed? Will we be able to watch the court hearings if there's a cross-examination?
Not at this point.
Okay.
I hope and I anticipate that the plaintiffs will be requesting that. And I think that, for the public interest, it's very odd for cases to be live streamed, number one, or even taped in Canada. We see that in the United States a lot more. And I really do think Canada needs to step up its game, especially in respect of such matters of public importance, that we should have this kind of record available to residents of BC and all of Canada.
Well, I'll have to agree with that. Eva Chipiuk, thank you so much for joining me today.
My pleasure. Thanks for having me.